Imagine you bought your dream home, you painted the door, you planted flowers, you put up a small basketball hoop for your kids in the driveway, and then a letter arrives. It's from your HOA, and it says, remove it, all of it, or face a fine every single day. Until you comply, you think, this is my home, I own this. How can they do this? And that's exactly what they want you to think, because they know something you don't. They know that hidden inside the very documents that give them power, there's a rule, a legal clause, something buried in the fine print that homeowners across America are discovering right now. And when you learn it, the balance of power shifts completely. Stay with me, because what I'm about to tell you is completely legal, widely ignored, and could save you thousands of dollars, or more importantly, your freedom inside your own home. Let's start from the beginning. Homeowners associations, or HOAs, govern approximately 74 million Americans. That's nearly 1 in 4 people in the United States living under the rules of a private governing body that was never elected by the public, is not accountable to the government in most states, and has the legal authority to fine you, lien your property, and in some extreme cases, initiate foreclosure proceedings over something as minor as a flag that's 1 inch too large. Think about that for a second. Foreclosure over a flag, this is not fiction. This has happened multiple times, across multiple states. In Florida, a retired veteran lost his home, a home he had paid off completely, because of an HOA dispute over landscaping violations that accumulated over $6,000 in fines and fees. In Texas, a family was fined repeatedly for having solar panels, even though state law explicitly protected their right to install them. In Georgia, a woman was taken to HOA court for having a garden that was, quote, not aesthetically consistent with the community standard. And in almost every single one of these cases, the homeowner had no idea that they had rights. Real, legal, enforceable rights. Rights that the HOA never told them about. Rights that, if exercised correctly, could have stopped every fine, every lien, every letter dead in its tracks. So how did we get here? The modern homeowners association traces its roots back to the 1960s. As suburbs expanded and developers built massive planned communities, they needed a way to maintain property values and ensure neighborhoods looked uniform. The HOA was the solution, a private organization that could set rules called covenants, conditions, and restrictions, or CC and RS, that every homeowner agreed to follow when they purchased a home in the community. On paper, it sounded reasonable. On paper, but over the decades, something changed. HOAs grew more powerful, state legislatures gave them more legal authority, boards became more aggressive, management companies hired by boards to enforce rules became more profit-driven, and the fees exploded. What started as a $50 a month service to maintain the community pool became $400, $600, even $1,200 a month in some luxury communities, with zero accountability for how that money was spent. And the rules multiplied. Some HOAs today have rulebooks that run over 200 pages, rules about the color of your shutters, rules about when you can park in your own driveway, rules about what kind of plants you can grow, rules about where your trash can sit after collection day, measured to the inch, and the enforcement, inconsistent, often personal, sometimes outright discriminatory. HOA horror stories flood Reddit, Facebook groups, neighborhood apps. Millions of people, frustrated, angry, powerless, sharing their experiences of being fined, harassed, and bullied by boards that seem to operate with no checks and no consequences. But here's what almost none of those posts mention, what almost no homeowner fighting their HOA realizes: the rule that is written, in most cases, directly into the same legal framework that gives the HOA its power. The rule that HOA boards and management companies never volunteer. The rule that, once you know it, changes everything. Here it is. HOAs are bound by their own governing documents. Every single action they take, every fine, every restriction, every enforcement letter must be specifically authorized by the CC and RS, the bylaws, and the rules and regulations of that specific HOA, not just generally authorized, specifically authorized, with clear language. And if it isn't, if the HOA is enforcing something that is not explicitly written in their own documents, that enforcement is legally invalid. Let me say that again, because most people don't fully absorb it the first time. If your HOA cannot point to specific written language in their governing documents that authorizes a specific rule or a specific fine, they cannot enforce it. Period. It doesn't matter what the board says. It doesn't matter what the management company sends you. It doesn't matter how many letters arrive at your door. If it isn't in the documents, it isn't a rule. And this is where it gets really interesting, because most homeowners never read their HOA governing documents. And many HOA boards, especially smaller ones run by volunteer neighbors, are equally unfamiliar with exactly what their documents actually say. This creates a massive gap. A gap between what HOAs claim they can do and what they are legally authorized to do. And that gap is your legal hack. Here's how to use it. Step 1. Get your governing documents. This sounds simple, but many homeowners have never actually read them. Your HOA is legally required to provide you with copies of the CC and RS, bylaws and rules and regulations. In most states, they must provide these within a specific time frame, often 10 days, and they cannot charge you an unreasonable fee for them. If they refuse or delay, that itself is a violation of your rights. Request them in writing. Keep a record of the request. Document everything. Step 2. Read them, all of them. I know 200 pages of legal language sounds like torture, but you don't have to be a lawyer to find what you're looking for. You're looking for two things specifically. First, the exact language that authorizes the rule they are trying to enforce against you. Second, the exact process they are required to follow when enforcing any rule. Because here's something most people don't know. HOAs aren't just required to have the authority to enforce a rule, they're also required to follow a specific process. Notice, hearing, appeal. In most states and in most governing documents, a homeowner has the legal right to a hearing before any fine becomes official, a right to present their case, a right to appeal a board decision. If the HOA skips any of these steps, the fine is invalid, legally challengeable, often reversible. Step 3. Document the inconsistency. One of the most powerful legal defenses in HOA disputes is called selective enforcement, and it is exactly what it sounds like. If your HOA is enforcing a rule against you but allowing other homeowners in the same community to violate the same rule, that is selective enforcement. And in most states, selective enforcement is a valid legal defense that can get a fine dismissed or a rule declared unenforceable. Drive through your neighborhood. Take photos, note dates and times, build a record. If your fence is in violation but 3 other fences on your street have the same issue, you have a case. Step 4. Respond in writing. Always in writing. Never just call the HOA or talk to a board member informally. Written communication creates a legal paper trail. When you respond to any HOA violation notice, you request, in writing, the specific provision of the governing documents that authorizes this enforcement action. You request, in writing, the complete enforcement procedure they are required to follow, and you state clearly and calmly that you intend to exercise your right to a hearing if applicable. This single letter, sent certified mail with return receipt requested, changes the dynamic of the interaction entirely, because now you're not just another homeowner who got a letter and panicked. You're a homeowner who knows their rights, and HOA boards, especially management companies, know the difference. Step 5. Know your state laws. This is critical, because above and beyond whatever your HOA's governing documents say, your state has laws that govern HOAs, and those laws may give you rights that even your HOA's own documents don't reflect. Florida, for example, has the Homeowners Association Act, Chapter 720 of the Florida Statutes, which gives homeowners specific rights including the right to speak at board meetings, the right to inspect financial records, the right to challenge fines, and crucially, the right to alternative dispute resolution before an HOA can take legal action against you. California has some of the strongest HOA homeowner protections in the country. The Davis-Sterling Common Interest Development Act governs HOAs throughout the state and includes explicit protections for homeowners' rights to reasonable accommodations, political expression, and internal dispute resolution. Texas, despite being known as a state where HOAs have significant power, has laws that explicitly prohibit HOAs from restricting solar panels, certain types of religious displays, and the display of the American flag. Georgia recently passed new legislation, signed in 2025, that requires HOA mandatory registration with the state, gives homeowners guaranteed rights, and reforms how HOAs can apply payments and pursue attorney fees. These laws matter enormously because they exist above the HOA's governing documents. An HOA cannot contract away state law. If your state law says you have a right to a hearing, you have that right even if your HOA's documents don't mention it. Now, let's talk about the money, because for many homeowners, this isn't just about a fence or a garden or a flag. It's about fines that have grown into thousands of dollars, fines that have been placed as liens on their property, fines that are threatening their financial security. Here's what most homeowners in this situation don't know: fines and assessments are not the same thing legally. In many states, HOAs have the authority to place liens for unpaid assessments, meaning your monthly dues, your share of special assessments for community projects. But the authority to place a lien for unpaid fines for rule violations is significantly more limited and varies dramatically by state. In California, an HOA cannot foreclose on a property solely due to unpaid fines. Only unpaid assessments can trigger foreclosure under California law. In Florida, unpaid fines cannot become a lien on your property unless a homeowner has been given the opportunity to appear before a fines committee, a separate body from the board, and the committee has confirmed the fine. If that process wasn't followed, the fine is unenforceable as a lien. This is the kind of information that HOA management companies who profit from enforcement have no incentive to share with you. But there's more. Let's talk about the board itself. HOA boards are made up of volunteers, your neighbors, who may have very little understanding of the legal obligations they've taken on. Board members have fiduciary duties to the homeowners in the community. That means they are legally required to act in the best interest of the community, not personal interests, not favoritism, not grudges. When a board member uses their position to selectively target specific homeowners, to retaliate against homeowners who have raised legitimate concerns, or to make decisions that benefit themselves financially, they may be violating their fiduciary duty. And that is a cause of legal action. Many HOAs carry directors and officers insurance, D&O insurance, precisely because board members can and do face personal legal liability for their actions as board members. If you can demonstrate that a board member acted outside the scope of their authority, acted in bad faith, or acted with discriminatory intent, you have legal options that go far beyond just contesting a fine. And speaking of discrimination, the Fair Housing Act applies to HOAs. This is another rule that HOAs hope you never discover. If an HOA's enforcement of its rules has a discriminatory impact, even if the rule on its face appears neutral, that can be a violation of federal law. The Department of Housing and Urban Development has taken action against HOAs for discriminatory enforcement. Homeowners have successfully sued HOAs under the Fair Housing Act. If you believe your HOA is enforcing rules in a racially discriminatory way, or targeting you based on national origin, religion, disability, or familial status, the Fair Housing Act is a powerful federal protection that your HOA cannot opt out of. Let's bring this all together. You don't have to be a victim. You don't have to write the check. You don't have to comply with rules that may not even be legitimate. You have rights, specific, legal, enforceable rights. And the very first step to exercising them is understanding what they are. Get your governing documents. Read them carefully. Request in writing the specific authority for any enforcement action taken against you. Document every interaction. Know your state laws. And if the situation escalates, find an attorney who specializes in HOA law. Many offer free consultations. Some take HOA cases on contingency, meaning you pay nothing unless you win. Because here's the truth about HOAs that the industry doesn't want you to understand. They are not the government. They do not have unlimited power. They are private organizations bound by their own documents, constrained by state law, and subject to legal challenge. They count on your compliance. They count on your fear. They count on the fact that most homeowners will receive a fine letter, feel powerless, and write a check. The moment you pick up your governing documents and start reading, you stop being just another homeowner. You become a homeowner who knows the rules, all of them, including the ones they hoped you'd never find. This is HOA Underground. The truth stays hidden. Until now, if this opened your eyes to something you didn't know before, share this with every homeowner you know, because this information belongs to all of us. Subscribe for more of what they don't want you to know. And drop in the comments, have you ever fought back against your HOA? What happened? Your story might help someone else find the courage to fight too.